Please be seated. General Hood, you may proceed.
May it please the court. It's my honor today to represent the state of Mississippi as the Attorney General. I'd like to introduce our assistants who have worked diligently on this case, Bridget Wiggins, Meredith Aldridge, and Alex Hassall, who are here today to represent the state. I'm the one who will be doing the arguments on behalf of the state, and I have argued probably before 100 juries, several times here at this court and at the United States Supreme Court. At no time have I ever been able to finish my argument and say all that I wanted to say, but I believe with 90 minutes here today I'll be able to do that. And so it shouldn't take me nearly that long. It's a very simple case. And the issues are very simple, I think. Now, the questions are the acts of the governor reviewable? And if they are, is the publication requirement of Section 124 a condition precedent to a governor granting, having the power to pardon? And third, what constitutes publication for 30 days? First of all, let me agree with the appellates that we agree that the wisdom of the governor in granting a pardon and to whom he grants a pardon or she grants that pardon is not an issue that we are concerned with. The wisdom, the decision that they decide who to pardon and so forth. What a court does have jurisdiction to address is whether or not that pardon itself is valid, whether it violates our Constitution. So many of the cases that the appellate...
In your brief, you referred to numerous facially invalid pardons. What constitutes a facially invalid pardon? First question. Of the 10 pardons that are before this court this morning, are you alleging that any of those 10 are facially invalid, and if so, why?
Well, Your Honor, it's our contention that those pardons did not comply with the constitutional requirements of the publication for 30 days.
My question is, were they facially invalid?
Well, Your Honor, I don't think that is really the issue.
That's my question, General Hood.
Well,
please answer my question, not tell me what the issue is. I don't want to argue this morning.
Yes, sir. I apologize. I didn't intend to argue with the court. What the pardons, they don't say, the ones that I've reviewed do not say, whether publication's requirement was met. There are pardons that do, that we think are valid. So we contend that the pardons are facially invalid. But there again, Your Honor, respectfully, we disagree that whether or not it's on the facial that it's valid or not. The question, I believe, is whether or not a court has the authority to review it. And there again, we agree that the wisdom of granting a pardon is not justiciable, not an issue that we're bringing to this court. It's just whether or not those pardons met the constitutional requirements. And when I first heard about these pardons, I'm like many other people. Well, the governor's got the power to do that. I remember that from 9th grade Mississippi history. The governor has the power to pardon. Then I recall, from our 10th grade history, American history class, we learned that, the powers when America became an independent nation were transferred from the crown to the people. And that the people, the government is below the people. And that the only powers that the governor or other officers have is what the people have granted them. So I looked at the Constitution, Section 124, and I read it probably 50 times since this began, because I kept thinking, maybe I'm missing something, because we all believe that the governors actually receive powers from the king. Well, it's right the opposite. So I looked at what the powers were that the people gave the governor. In our 1832 Constitution, there were no powers, no restrictions on the pardon power. In the 1869 Constitution, there were also no restrictions on the pardon power. Restrictions on the pardon power were taken back by the people, if you will, in the 1890 Constitution. And that's when the publication requirement was placed in. So the people gave unrestricted authority to a governor to pardon. We delegated.
Why are you saying you're drawing a distinction, General Hood, between restricted and unrestricted? I don't see anything in our current Constitution that restricts the governor from issuing these pardons. Whether or not these notices were or had to be filed is a different question. The governor, do you concede that whether or not the notices were filed, the governor still had the power to pardon? There's nothing about the notices that prevents the governor from proceeding to issue every one of these pardons. So I'm having trouble with the use of the term the people restricted the governor's power.
Well, the people in 1832 and Constitution, 1869 Constitution, they did not have the publication requirement in there. So what I'm saying is based upon treaties and the Clarion Ledger in September 26th and 27th of 1890, and the Constitutional Convention journals that we have submitted to the court, those show that there was a debate as to what limitations should be placed on the power of government. And the history indicates that there was some abuses by prior governors. In fact, there was a movement among other states to grant that power, instead of giving it to the governor, give it to the legislature. In some of these states that we cite these cases. And so during the 1890 Constitution, there was a debate as to whether or not to, how that they should limit it, what the publication requirements should entail, what it meant. And so all that was discussed at the Constitution.
Let me ask you, General Hood, I think I understand what you're saying regarding Justice Dickinson's question, but the power under the 1890 Constitution, the power of the governor to pardon is still unrestricted, but I take it your position would be that even though he can pardon or attempt to pardon anyone he wants to for good reason, bad reason, or no reason at all, that he has to follow certain procedures. Is that what you're saying, including publication?
Yes, sir. You stated it much more concise than I was able to do. What I'm saying is that this is a conditioned precedent. It's that the people said, Governor, you don't have the authority to pardon until, and that's what the Constitution said. That's why I read it so many times. It says that after conviction, no pardon shall be granted until the applicant shall publish. And that says that no pardon shall be granted. That's mandatory language.
What if there's no applicant?
Well, there's always got to be a presumption that someone has applied for it.
Why?
Because
are you taking a position the governor cannot simply decide to pardon someone who did not request a pardon and maybe even doesn't want a pardon? Do you concede the governor has the power to pardon anybody?
Attempt to, yes, sir.
But why does there have to be an applicant?
Well, if there weren't, you could just write out that section. Every governor could just say, well, nobody applied. They might have applied to the parole board or somewhere else, but they didn't apply to me. So I don't have to worry about that constitutional provision. You could just, if you interpret it that way, we can just write that section out of the Constitution. But it meant something. It meant something to the people.
General Hood, you said that Governor Bryant yesterday could not have issued a pardon for Mr. Turner at 5 p.m., 5:30?
He could have commuted a sentence. See, the commutation of a sentence is not subject to the 30-day provision.
Where does that come from?
The commutation?
Why do you say that's not subject to 30-day provision? Where does the authority to commute the sentence or medical release or suspend the sentence?
That last sentence about pardons, the publication only applies to that. I don't see in here, it talks about up here commutation of sentence and so forth. But as far as a pardon, it just says pardon. It doesn't say, the commutation of the sentence. So we take the position that last sentence just applied to pardons. That's all they talk about at the Constitutional Convention was just pardons.
You think the 30-day requirement for publication only applies to a full and complete pardon?
Yes, ma'am. That last sentence just talks about pardons. So
that's the plain language of the Constitution, is it not? Section 125.
Yes, sir. And that
says no one shall be pardoned until his application has been published 30 days
Yes, sir. It says after conviction. I'm sorry.
Is it necessary to publish for 30 days before the governor signs the pardon?
Yes, sir.
But it doesn't say before, it says until.
Yes, sir.
Which brings us back to the argument Mr. Blackman was making. Once you start reviewing the language, everyone has his own interpretation of it. Is that not correct?
Well, several courts have addressed this issue of the 30-day period.
Okay, tell me more.
And we cite several, many of them from out of state, because as I said, there was a movement.
You cite Kansas State.
Yes, sir. There
which
are.
does not apply to Mississippi at all, does it? Because Mississippi does not have in that section any language limiting the governor's power and giving that power to the legislature. The legislature has no part in the pardon pertaining to Mississippi's constitution, but it does in Kansas, which is totally different. Ours is more like the Montgomery case. Do you agree? That is here in Mississippi that we've decided, I believe, in 1954.
Your Honor, the pardon power that you suggested in the Kansas case, that Constitutional Convention in Kansas decided we're going to let the legislature decide that there have been some abuses. We're going to let the legislature regulate, put some regulations on. What's so important about ours is our people reserve that constitutional right to have notice and a hearing. Due process, the very foundation of our system of laws as opposed to men.
That states
that reservation
must be published for 30 days, and the pardon cannot be granted until. Which brings me back to one of Justice Dickinson's earlier questions. When does the pardon take effect? If you look at the two documents that are provided for each pardonee, the governor's signed statement indicates at the top of that document that it's an executive order. If you look at the Secretary of State's document, it's entitled an official pardon. So when is the pardon granted?
I agree with Charles that it agrees that it's effective when the governor signs it. But what our position is it's a conditioned precedent. Publication is a conditioned precedent. He can't do it until he has made sure that the publication requirement is met.
And excuse me, you said something that I don't think I've heard before, and I appreciate you following up on it. Now, you said that there is always a presumption that someone has applied. Where in our jurisprudence do you find that presumption? I mean, aren't there many cases where nobody applies and the governor just says, I'm going to pardon that fellow? And that if there's not an applicant, it doesn't seem, from reading this section in the Constitution, that the publication requirement is triggered. Do you agree or disagree with that?
Your Honor, as I said, if that section wouldn't mean anything if every governor could circumvent it. So I think logic would dictate that we have to do like the Montgomery Court in Montgomery versus Cleveland. That court showed that a governor in 1923 knew how to do it. In fact, in the second paragraph of it, in that stipulation, they talk about the first paragraph. The governor went to Memphis. What happened? He left the state, took off from here at 12:30 and crossed the line that next morning around 6. And the lieutenant governor about 10 that morning signed a pardon. So the director of pardons, he's called the Secretary of Prisons, I believe, refused to accept that pardon as being valid. So I suspect that the governor didn't like that fact of what had happened. And so the Attorney General represented the Department of Corrections. And the first thing any lawyer is going to do, I suspect, to look at is what are the conditions and what does that section say. And so obviously, since there was publication properly proven, as it says in that second paragraph of Montgomery, it showed that the governor at that time knew how to keep a file. And the governor had a file, and in that file was the application of the petition for pardon, as well as the proper proof of publication proved. And they expressly say it twice, publication, and then that the publication was properly proved. So
You're right, in that case, there was an application. What I'm asking you about is why do you say there is a presumption that there was an application if you can't pick one up and look at it? If nobody asked for a pardon, if nobody applied. Section 124 talks about, in the notice part, two things that are significant to me. One is applicants, and that, of course, implies that someone has applied or someone has requested or asked for a pardon. And the other one is petition, which is another form of an application. And where you don't have either one of those things, nobody's asked for a pardon, nobody's petitioned. Why is there a publication requirement in a case like that?
Justice Kitchens, I think there again, it's a condition precedent. So if there's not an application, and it's not...
I know you think that, but I'm asking you, why do you think that?
Well, I'm trying to get there, Judge. I'm saying that if there's not an applicant, and there hadn't been publication, and the governor does not even have the power to grant that pardon, because it is a condition precedent to that governor signing that pardon.
That the governor pardons.
Sir?
Suppose the pardonee, we started calling these folks, suppose the pardonee has died, and the governor looks at that case and says, well, you know, that person ought to be granted a pardon posthumously after his death. And nobody asked him to do it. He just thinks it's the right thing to do. He does it. There's no application, there's no petitioner, and the one he wants to pardon is in the cold ground. So is there a requirement that somebody publish something in the paper before the governor can pardon that person?
Yes, sir. Most all of them had lawyers. For example, in Montgomery versus Cleveland, 1923, it was a lawyer from, apparently, the Eastlands lived in Forest at that time. He was a lawyer named Eastland that brought the document to the lieutenant governor, got it signed, and then took it up to Parchment, or to the penitentiary.
I think it was even Woods Eastland, if I remember.
Yes, sir. I believe that's right. So most of them have had a lawyer that knows to publish. Now, he wasn't deceased in this case, but somebody, a representative, still can do the publication. But there again, the governor does not have authority. The people took it away when they put this publication requirement in there because they said you can't do it until.
Akin to what Justice Kitchens has asked, in the state's brief, you make the statement that once the governor got it in his mind that he was going to pardon the management trustees, that effectively that became an application. What's the legal authority for that statement?
Well, if you're going to interpret this constitutional provision, you have to say that before you can grant a pardon, there's got to be an applicant.
But, you know, back years ago, during my legislative days, there used to be talk of what was called general do-right bills. No authority for anything, just an admonition to do right. My question is not whether or not this is just a general admonition, but whether or not there's any legal authority for that position. I did not see him cited in the brief.
No, Your Honor, there's not, because there again, we hadn't had a case like this. You know, most of the other governors didn't grant a large number of pardons at the last minute.
Is it the number that makes the difference?
No, sir. It's just, well, what happened is that caused a lot of confusion, like the lack of files and so forth. But as far as, to logically interpret this constitutional provision, if our position is what we believe to be correct, is that the governor does not have that power. People took it away in 1890 until that he makes sure that he or she makes sure that there's proper publication proven. And in 1923, they knew how to do it.
Attorney General Hood, in the history of this great state, has there ever been an instance where the Attorney General has attacked pardons in the history of Mississippi?
There's a case here in Montgomery where the Attorney General was
at the behest of the governor, though. At that time, he did that at the request of the governor. And I'm getting to this. David Scott, do you dispute the fact that an attorney working under your office provided advice to the governor's office regarding the pardons?
Well, first, as to Montgomery, the Attorney General was defending the Department of Corrections. I wasn't the governor.
Okay.
wasn't defending the governor.
Fair enough.
So I was defending that. Now, absolutely. I mean, the text messages, this really ought to be discussed at trial, because I'd love to put some people on and get some depositions as to who did what, but we had text messages from David Scott, who's been a long-time Assistant Attorney General. And that first text message, the Commissioner of Department of Corrections said, somebody at the governor's office called me. Will you call or contact Darrell Neely? He was a contact at the governor's office and advise them on what the requirements are. And in that text, David Scott texted Darrell Neely on November 28th, long time before the pardons were granted. And in that text, it said, look at section 124 of the publication requirements. So it rocks along. Then there's a message that comes back. It's an email from David Scott to the commissioner, and then David Scott tells the commissioner that the governor's office has reviewed it and that they don't believe that the publication is necessary. The next thing we get is after 5 o'clock on December 6th, 31 days prior to the January 6th first series, the first 5, the trustees at the mansion, their pardons, requesting, it says the big guy, or the man at the top, now wants to publish.
And I understand all that, but my point is this. The standing issue is very, very lightly touched on in the governor's brief, but they allege you do not have standing. Would it be best for the individual district attorneys in the respective counties in which the crimes occurred to take this on as opposed to the Attorney General in light of the statutory duties that are implied that are certainly yours, and in light of the obvious conflict between Mr. Scott and the position you're taking today?
To answer that, Your Honor, several of the district attorneys are here and represented here with themselves, but the jurisdiction is in Hinds County. That's where the acts occurred. That's where the pardons were granted. And so the venue is proper here in Hinds County. The Attorney General has authority in the Elaine v. PSC case, and in that case, this court said that the Attorney General can represent both sides in a controversy, even if the Attorney General is a party. That's, remember, Governor Lane sued PSC over electric rates. And that's what this court has held, and there is no conflict. David Scott is one of the, other than me, he's probably one of the hard-headed lawyers we have. And
let me ask you a question on this conflict situation, because I thought I heard you just say that on November 28th, that the lawyer for the Department of Corrections, Scott, told the executive office to look at Section 124.
And the publication requirements, yes, sir.
So that was the position the Department of Corrections is 124 control.
Yes, sir. He was conveying the position of the Department of Corrections and what the law is.
And then some communication come back later, well, the executive office lawyers don't agree with it.
An email from David Scott to the commissioner, Christopher Epps, said
Epps or to Neely?
Yes, sir. It just said that now the governors had discussed it and they don't think publication is required. Then the next thing to get is at the last hour, now the governors decided they need to publish. So David Scott is not, he's just conveying the messages back and forth.
So is it fair to say that there was a debate between the executive office and the lawyers for DOC as to what the law said?
No, sir. There was no debate. MDOC is under the governor. And so it wasn't for MDOC to argue with the governors whether it needs to be necessary. All they did
I'm not asking about an argument, but you're telling me that the DOC attorney said 124 controls, some other lawyer said no, and there's an acquiescence because the governor controls DOC.
Well, the governor has, I think, 3 staff attorneys on board, and apparently they discussed it. But then the governor changed his mind and came back and said no, publish. Now we're just talking about publication on the trustees at the mansion trustees.
Well, since we're talking about publication, let's go to Ms. Stewart's clients for a second and separate that. What is your position as to whether Zambili and Howard met the 30-day requirement?
If I recall correctly, they published for 4 weeks back in the fall. I think I'm right on which one.
4 weeks completed before
yes, back
the
September,
30 days
but it was
before.
just, they published
Ours published November 29th through December the 20th, and Gambuli November 3rd through November 24th.
Thank you, Justice Carlson. Well, our position is they just publish for 28 days. I mean, 4 weeks is 28 days. And on the 30-day issue, we cited to you constitutional provisions they were in the 1890 Constitution where the drafters knew they could have said 4 weeks.
Couldn't they have said consecutive days as well?
Yes, sir. But they knew how to say once a week for 4 weeks.
But General,
As I said,
that's in direct conflict with the Henritzi case that was decided here in this state, wasn't it, in 1938?
yes, sir. Henritzi was decided on a case out of Missouri called Glasgow. And Glasgow, the same justice that wrote Glasgow turned around, I believe 3 years later, in Callahan and distinguished Glasgow. And what the court found, was that what was said in the Glasgow case was not less than 15 days previous notice. So what the court came around in Callahan and they said, this provision they were discussing in Callahan, it said 4 means every time it's published. So our court based it upon a decision of another court that distinguished it. That's one issue.
You're saying that case is wrong.
Yes, sir. Unfortunately, that it was based upon a case that a court turned around its decision on at a later time, and it was loose language that is not nearly important as the Constitution.
What's loose about this? It was published in a newspaper weekly for 4 consecutive weeks, and they held that was equivalent to 30 days.
Yes, sir. That was a condemnation case down on the coast. I think they were building Highway 9, and it was a statute that required that publication. But what we're doing, we're construing the Constitution. If this court makes the wrong interpretation according to the legislature of a statute, then they can fix it. But you can't do that with the Constitution. The Constitution has to be read strictly and in terms of when it was written. And so our history in this case in 1923 in Montgomery, it showed that they understood how to properly get a file and put it together. And
Mr. Hood, General Hood,
yes, sir.
you argue that the governor's power was restricted when the Constitution was changed in 1890 with pardons. Well, that's when the applicants and the notice began.
Yes, sir.
There's been no challenge to any governor's pardon since then, other than the Montgomery case, which had to do with the authority of the lieutenant governor versus governor. Is that a fair statement? No challenge since then?
No, sir, none that I'm aware of. I mean, the court looked into the validity of Montgomery.
Well, the facts were stipulated. The issue there was lieutenant governor was not the governor, so he couldn't pardon. So
if they didn't properly publish, I don't think that stipulation, the issue by inference would have been, obviously that would have been an issue and it would have been addressed on all fours. But since it was properly published and proven, then they went on and just decided the issue about the lieutenant governor didn't have the powers of government.
okay, but other than that case, there's been no challenge to a pardon since then.
I don't know the in court reported case. Now, I do know of one governor correcting another governor's pardon.
Well, back to your knowledge, has every governor since then followed Section 124 as textually as you present today?
I'll give you an example.
I want you to answer my question. Has every governor since 1890, textually as you argue today, followed those provisions?
Has it been challenged in court? No, sir.
No, that's not what my question was.
Have they followed it?
Yes.
Well, best I can do, Judge, is tell you about what your father did, Governor Waller, in correcting an attempted pardon by Governor John Bell Williams. And in that pardon, Governor Waller, the only one he gave, he expressly stated that Governor John Bell Williams pardoned this guy of one crime. But because he says this, I can read from it here, the pardon. But he says in there that the reason he couldn't pardon him on the other one because the